Hello, good evening and welcome to another program on Law and Order. Now we all know that competition is something that the business environment use to attract customers. Any type of business we do have competition. But the question in competition always comes up is whether free and fair competition is possible. There are schools of thought which says free and fair competition is a pillar of an efficient business environment or efficient business regime in any country. Now, the law relating to competition, or sometimes it's called antitrust law in some countries, try to grapple and bring the bridge between these competitions, between the same product between two countries or two parties or two companies, and try to give a good flair and a level playing field for free and fair competition. But our question is whether it is successful or whether it can maintain, because we are at the end of the day dealing with humans and people who want to make the most out of what they produce in any business environment. So today, to go to the heart of the matter of what is competition law and what is antitrust law, we have an expert like always. My expert guest today is no stranger to Rupawani. He has been here before, Dr. Sampath Punchiheva. Dr. Sampath Punchiheva is a lecturer of law in many areas in the University of Colombo and especially in the area of competition law as well. Thank you again accepting our invitation, Dr. Sampath, and coming to Channel I Law and Order. How are you today?
I'm fine. Thank you for inviting me for this program.
Yes. Let's ask the obvious question. What is competition law? Can we start there?
Yes. Yeah. Competition law is something not very well known in Sri Lanka for the reason that we have not thought about competition regime in this country. However, the competition law has been not a new phenomenon in the international level. Competition law is, it's referred to antitrust law or antitrust law in in the US, and in Europe and some other parts of the world it is competition law. Competition law mainly deals with anti-competitive practices and prevent monopolization of big firms having dominant position in the market, and the law dealing with anti-competitive practices and monopolization would be a simple definition to competition law.
Now, how is it different from protection against unfair competition? Is it different or is it the same thing?
Very rightly questioned, Chanakya, because in the IP Act, in the IP Act of Sri Lanka, Act number 36 of 2003, Sri Lankan IP Act has provided detailed provision on protection against unfair competition. That is, if one enterprise behaves in unethical manner, it is a competition, prevention of competition contrary to honest practices. So it is something coming under the IP Act. But what we talk today is not the competition protection against unfair competition. That is, we are not talking about the good practices in the competition. However, the competition law, antitrust law, is dealing with the monopolization, market dominance, and anti-competitive practices committed by firms. Business entities. Yes.
Yeah. Now, I know. That's a very common misconception you cleared now.
Yes.
Now, is there a law in Sri Lanka regulating the competition in the market?
Yes. Maybe, may not be answer. Why?
Yes,
because yes and no. Yeah. At the moment, the current legal regime, if you look at the legal landscape of Sri Lanka, we do not have a competition commission.
Right.
We do not have a market regulator as such. Even though we have Consumer Affairs Authority Act.
Right.
And by virtue of Section 8, the Consumer Affairs Authority is vested with certain powers to prevent anti-competitive practices in the market the law is, but I don't think that there is a proper mechanism or proper legal framework in the country with a suitable mechanism, institutional framework to enforce competition law in this country.
Okay, basically it's non-existent. Now, antitrust law, I think is a very big thing. If I may to take example, United States and Europe.
Yes.
And you studied and you have exposure to Europe and other countries. Now, how is their give me an example from a country which you know,
yes,
which is successful,
yes,
in the drafted practice antitrust law.
Yes.
Or the competition
yes,
law, they want to call it.
if you take the US, United States had drafted a number of legislation dealing with anti-competitive practices. One is this Sherman Act. The other one is Clayton Act, and the other last one is Federal Trade Commission Act. All three pieces of legislation deal with antitrust law, monopolization, anti-competitive behavior practices by firms or the business entities. Whereas in Europe, we have competition commission, European Commission, dealing with competition issues, anti-competitive practices. That is by virtue of Lisbon Treaty or Treaty on Functioning of Europe. That is called Lisbon Treaty, and Lisbon Treaty by virtue of Article 101 and 102 deal with competition law in Europe.
Right. Are we a signatory to the Lisbon Treaty, Sri Lanka?
No, this is Chanakya, very good question. There is no single instrument at the global level dealing with competition law or antitrust law so far. Whereas when we look at the protection against unfair competition, we do have TRIPS agreement and Paris Convention.
And we are signatory to those.
Yes. TRIPS agreement, we are one of the first countries to sign that instrument. Yes. However, at the global level, the norms are there. However, there is no single legal instrument dealing with competition law. Countries in the world more or less adopted US practice or the European practice.
Okay, what is the healthier practice? Let me rephrase that.
Yes.
Healthier practice. Now, we have come across laws which are draconian.
Yes.
And some laws in some countries are draconian.
Yes.
Is the US system, if we are to adopt, because Sri Lanka is not adopted,
yes,
healthy to adopt for us to take a guidance to draft our own law, or the European is better?
I would say both models.
Both models?
Both models have certain best practices.
Right.
And US law is more like it was the first exposition of piece of legislation dealing with competition. Whereas the European law is rather latecomer.
Right.
However, through the jurisprudence emanating from European Court of Justice, the European Commission, there is a plethora of valuable cases or the leading cases in Europe. For example, Microsoft case. And the firms in Europe are very careful when they make the investment in the European countries. So same is true in Sri Lanka. Now, if you want to, if the government policy is directed towards creating a conducive environment, Sri Lanka might have to foresee competition law, because when an investor comes to Sri Lanka, they will also look at the legislative environment, legal environment of the country. When we don't have, then that might affect the companies, the business entities in Europe. That is why I think time is ripe for us to look for the kind of a legal instrument, specific, dedicated legal instrument dealing with competition laws.
Yeah, so you say, telling in other words, take the best practices from both countries and create our own law.
that would be the best approach, because the American law is dealing in a different way when we compared with the European law. But European law is leans towards more consumer welfare approach. American law is more into Chicago School of Economics.
What does that mean?
That is the set of
nice phrase,
the legal and economic scholars advocating theories, freedom of markets, freedom to operate, and how to regulate the markets. This is it's a religion. It's called it's a religion in the Chicago, emanating from Chicago School, which has shaped the thinking in the American legal scholars in relation to antitrust law.
Right. Now, Sri Lanka, as you know, from time immemorial, from the beginning of our open economy, we are sometimes desperately and most of the time creating institutions, whether it's a BOI, whether it's a megapolis, whether it's a port city or whatever, looking at FDIs or foreign direct investments. So, which means Sri Lanka is looking for investment. How important is competition law or antitrust law to create a conducive investment climate?
Yes, a very appropriate question, because Chanakya, when a country creates policies and legal policies conducive for investment, that country is obliged to introduce legal provisions to back it up. And Sri Lanka does not, at the moment, Sri Lanka does not have a competition policy. Neither does it have a robust competition law. That is, in my view, it is in my belief that Sri Lanka should think about this, because now, Chanakya, I have seen we are talking about rice mafia. And we are talking about shipping companies having issues with regard to the access and use of the facilities. And in some other areas we have with regard to supply of gas, sometimes with regard to provision of telecommunication services. And there will be only few entities handling the landscape of the industry. And which would lead to monopolization in the market. And it would harm the interest of the consumers. Because if you have the monopoly or the dominant position in the market, eventually what happens? Then the market player would definitely abuse its position and sometimes tries to chase away the competitors. That is called predatory pricing. So in one case in Sri Lanka, this is it is reported, Ceylon Oxygen Limited versus Fair Trading Commission, 1997, two Sri Lanka law reports at page 372. It's a very typical example. Though this was coming under Federal Trade Commission Act, it was a very simple and very far-reaching example in the Sri Lankan context, where the one dominant player would try to reduce the prices in order to chase in order to see the competitor is out of the market. And then later on they will increase the price because there is no competitor, and then there is no challenge. And if there is no proper law, companies, entities are becoming big and bigger, and they will definitely manipulate prices, and they will have time arrangement. If you buy this product of mine, I will also sell, I won't sell you the most important products of mine, like in Europe, like blockbuster film. Okay, it has great demand, but I have repertoire of other films also. If you buy other products other products from my company, I will sell you the other most demanded product. Same can happen in the health sector. If you buy medical products, other varieties of medical products from me, I will sell you the most demanded or most important profit-making product.
Right, that's correct. Is there one or is there international instruments, one or few, UN instruments or whatever, regarding the antitrust?
No, as I mentioned at the very outset, it is
not the Lisbon Treaty.
No, Lisbon Treaty is for Europe.
Europe
it is
only.
called it's called European Treaty.
European Treaty.
It was agreed in Lisbon. We call it Lisbon Treaty, but it is European Treaty.
Right.
And European Treaty can be like in computer crimes. We Sri Lanka has signed the Budapest Treaty. Budapest, like that. Maybe Sri Lanka can see the emanating or the emerging examples, experience from other jurisdiction. We don't have to look far. Why don't we look at Indian experience? Indian Competition Commission has been very active. And Indian Competition Law of 2002 is a good piece of legislation. Model designed by looking at European and the US experience. I think Sri Lanka might have, it's time for Sri Lanka to revisit Sri Lankan legal system.
Right. Now this anti-competition or competition law, antitrust law, all deals with this subject of monopolization.
Yes.
What would be the typical definition? Now we went to across the board, we said about different functions of different companies. What would be the definition? Legal or economic, is that differs of monopolization?
You want the monopolization to be defined?
Yes.
Yeah. If a dominant firm attempts to take advantage of its monopoly power in the market, it can be monopolization. Otherwise, it can also be abusive conduct by a dominant firm in the relevant market.
Right. That is the legal definition, as well as are the economists and the business world having a different interpretation for that?
Monopolization.
It's almost the same.
No. From a business perspective, it may be, you monopolize mean you are attempting to dictate terms to the market or to the consumers. But in law, first you should have monopoly, you should have dominant position in the market. Second one, you have engaged in anti-competitive practices. If you look at, if one firm can establish these two requirements, then it is in the eyes of the judiciary, there can be monopolization, or the act of monopolization can be constituted.
Okay. How is this regulated in massive economies like Europe and US? And for monopolization, what is the penalization?
Yes, very good question. In Europe, you will see...
It's different, is it?
In Europe, it is the European Commission.
Right.
European Commission generally imposes huge penalties. Huge penalties. In the US, it is the Federal Trade Commission.
Right.
They will investigate any complaint on anti-competitive practices.
Right.
And then they will interfere into market, and they can warn the entity who is engaging in anti-competitive practices, and not stopping that there and going into imposing penalties, and it's huge penalties, fines. That is how the establishments, regulators, I would say competition law regulators, act in the market, free market.
Right. Now, apart from the penalties, is there also stopping the practices? Will there be orders to stop the practice immediately?
Yes, absolutely. Because if you go against the order or the direction of the competition commission, that would violate the law.
Okay. The laws of US as well as in Europe, do they allow them to work on or go against the monopolization or anti-competitive practices of products of companies which are not in that jurisdiction? For example, if I were to take explain this further, we'll say we brought in an anti-competition regime in Sri Lanka. Then we have, as you know, whether it's the telecom industry or several other industries, international, multinational, very powerful companies which are shaping the industries, the subject matter and the people's mindset. Will we have power, jurisdiction to regulate them? Is it happening like that in Europe or America? Or any
absolutely. Now, for example, the Microsoft company was incorporated in the US, but they did business. They engage in business activities in Europe and across 28 countries. And they were found abusing its dominant position in the market. And European Commission investigated and they launched an investigation, and then they found that Microsoft company was in breach of antitrust or the competition laws in Europe and impose huge penalty. So that can happen. So
that's in the spirit of the law of antitrust law, right?
Surely.
That you can regulate laws of other
other companies. Because they do business in this jurisdiction. So if you enter Sri Lankan jurisdiction and you are coming into the scope of the application of Sri Lankan law.
Okay. You said basically there is virtually non-existent of anti-competition law regime in Sri Lanka. But is there any way a person who's watching us, who has this question about a particular industry or a company, can approach our judicial system by using any existing instruments? To your knowledge?
It should be
in a roundabout way.
That's an excellent, because in the end we should see how the law benefits the industries, industrial landscape. And I think, I would say, we do have certain provisions in the Consumer Affairs Authority Act of 2003. But I don't see the Competition Commission in Sri Lanka to regulate the market. And maybe I need to look for the information. I think Shipping Act might have certain provisions. And telecommunication law dealing with telecommunication, I think it's
individual subject specific acts will have provisions which can be invoked.
Yes, Public Utilities Commission of Sri Lanka Act 2002 might have provisions. So we might have, it's bit and pieces, but what I stress here is that Sri Lanka should have more dedicated specific piece of legislation to deal with emerging need of having competition law in Sri Lanka, because Sri Lanka has been an exception to the general competition laws in other countries. So it might be disappointing for the businesses in Sri Lanka for not having robust competition law regime.
Dr. Sampath Munchewa, thank you very much for joining us today. And thank you for touching on an area which we educate not only public, also lawmakers to make laws, because like you said very correctly, it is a necessary law for any investment incentive, as an investment incentive. And we hope to see you once again here, and thank you for joining us on Law and Order.
Absolutely.
Today. Thank you very much.
Yes, thank you very much.
That's Law and Order for today. We'll join you next week at the same time on another program on Law and Order. In the meantime, you can go to our Facebook page, Facebook/Law and Order Channel I, and join the conversation. And you can go to our channel page, that's channeli.lk, and go to on the drop-down menu, pick Law and Order, and watch the programs all over again if you wish to. Have a good evening, a good weekend, and enjoy the rest of the programming on Channel I. Good night.